Act and also Indiana Code 36-8-3-4 concerning police officers, firefighters, and disciplinary action, demotions, dismissal, etc. under that statute. The Safety Board heard a presentation by Chief Tritipo concerning an incident that occurred on October 5, 2024 concerning the discharge of a firearm in the town hall. Chief Tritipo presented information concerning the discharge of the firearm, the damage done by the discharge. He also presented information concerning thorough inspection of the rifle which was involved in the discharge, and finally presented video evidence providing some view of the incident in question. At the conclusion of the chief's presentation, Officer Wright made comments. He stated that while he admitted the facts of the violation, he felt that the punishment previously imposed, which was in the form of a 5-day paid suspension, was appropriate. He stated that he had taken additional measures of a corrective nature in terms of additional firearms training and so on. If this body is to impose any additional disciplinary action, it must be based on the facts as you have heard them this evening, and it must be on the basis of, as I said at the outset, neglect of duty, a violation of rules, neglect or disobedience of orders, incapacity, absence without leave, immoral conduct, conduct injurious to the public peace or welfare, conduct unbecoming an officer. Based upon the charges as proffered by Chief Tritipo, it appears to me, but I do not make decisions or set policy for this body, that the evidence would focus on neglect of a duty, i.e. the duty to promptly report, and B, violation of rules, being the policies that have been indicated by Chief Tritipo. Any other breach of discipline can also support additional disciplinary action. That's not defined in the statute. So with that, you may open this up to discussion. As I said, you have a range of choices. Based on the information presented and received, the Safety Board declines to take any further disciplinary action, or based on the information presented and received, the Safety Board determines that additional disciplinary measures are appropriate. In addition to the prior suspension with pay imposed by the town police chief, and the board now imposes an additional suspension of some period of time with or without pay, or based upon the information presented and received, the Safety Board determines the termination is the appropriate action, and the employee is terminated on a given effective date to be determined by the board.
I'm looking at a negligent act and was failure to respond to a superior officer or a council member in violation of policies are good enough reason to go on to further action, which in my opinion would be dismissal.
Any other discussion on that?
My concern is the attempt to cover up. That I think in the future would lead to issues with court cases and integrity of an officer, integrity of our department.
Tom, do you have any reason to say that this was a cover-up?
I don't think it was a cover-up. My intent was purely to fix the damage that I caused. The policy said you're responsible for the damage. Again, I reported damage to the town secretary, which was not appropriate, but certainly I wasn't trying to cover it up, by not reporting it. Like I said, I did attempt to correct the damage that I made, and I took full responsibility for the damage. but then in my email and my statement. So I feel like it's not a question of integrity or a cover-up to that degree.
I feel like it is a question of integrity when you should go to the superior officer or the council. To me, that's negligence on the integrity part. So is that a motion, Larry?
My motion would be for dismissal.
Any other discussion on this? All in favor?
I'm not,
Aye.
nay.
One nay.
You may,
Right, so the safety board has determined that dismissal is the appropriate sanction, and when is that effective?
How did you come up with the original, plan for for the warning?
What do you mean?
You said you had told me that you talked to Shelby County and what they would do on some occurrence like this.
Correct, I spoke with Shelby County, I spoke with some other agencies on how they would handle if someone discharged the firearm and then didn't report it and then covered up the evidence and such, and they said they would terminate it.
So when's dismissal, guys?
Well, the question, in any dismissal, there's always some protocol and paperwork and so on, so.
Correct, and the issue that we run into under the current statute that falls under the town marshals, the difference we have is as far as the sheriff's department or other larger agencies, they can suspend up to 15 days, which means they can complete the investigation and have everything finished within 15 days. However, state statute does not allow us to do that. State statute only gives us the ability to suspend for 5 days, which means regardless that the person has to return to work prior to the conclusion of the investigation and the full, I guess you would say, decision of the board. We do not have that time without it going on a longer period.
Now, you do have, the chief is charged, entitled, under state statute, to unilaterally make a 5-day suspension. He cannot.
We just dismissed, council. So what we're deciding is when the dismissal takes place. Is it
Well-
effective now or?
What I'm suggesting is you have the power to impose a suspension pending dismissal.
Right, and we just dismissed. So when's the dismissal?
I have a question again. You said that, because if that was the case, I never was aware that Shelby County said dismissal. That's why we gave them the warning, and what was given on the warning.
I don't understand the statement.
When we said that we talked to Shelby County, what would be the action taken? That's what you said, the action would be taken. That's why that was written on the written warning. And taking classes, a 5-day suspension.
Are you talking about the plan for improvement?
Well, I have a written warning that you have down, and it states what you suggested to be the written warning.
And then further action is taken to the council.
Deputy Marshal Wright will be
additional infractions can result
assigned
in
to remedial
suspension
8-hour
for pay
clock.
or termination, pay or termination.
Yeah, at the bottom for the plan of improvement, it states.
Well, that's not the original write-up that I have for
This is
the
the one
county
that was
Morristown.
submitted and signed right here. It's in your file folder.
On
And signed by you.
10/8/24, we have an email.
This is the one that was submitted today, that is the true, that is signed by him and myself. This is what was.
I'm just
submitted
asking about the
today.
10/8/24
Again,
written
that-
warning.
Anything prior to this that would have occurred would be null and void, because this is the signed copy of what was introduced as evidence. Anything prior to that would not be evidence.
Can I add a comment?
Yeah, absolutely. Public meeting.
Well, I would like to comment that further disciplinary action is directly in violation of our policy on disciplinary. I refer to policy 1009.11.1, which dictates the review hearing that we had. And it says in there that town marshal notifies the town board in writing within 48 hours of the action, which he did. Unless the employee seeks timely review, the proposed discipline becomes final. So, to me, to reopen this, to impose additional disciplinary, not only is in violation of our own policy, but it imposes a double jeopardy standard where you're now continuing to discipline employees for the same violation over and over again.
I believe the town marshal disciplined, which he had the ability to do. I believe state law also says there's a safety board that can discipline.
Yeah. What I tried to say a few minutes ago, the marshal can impose a suspension with or without pay for 5 days, not more than that.
That's all it can do.
That's all he can do. Any further discipline has to take place by the safety board. And in this instance, Officer Wright has received frankly more due process than the statute requires, because the safety board can impose discipline under the statute without affording the officer a hearing. If discipline is imposed, then the officer may request a hearing. And again, he's entitled to witnesses, counsel, etc. So in this instance, you provided a hearing so that you could hear both sides of the story. And I believe that, again, the statute, if you will, takes precedence over the policy, and the policy can be read, I think, as the chief suggests, it's an incremental process. Yes, the 5-day suspension closed, there was no request for a hearing, it's over. But again, after the conclusion of the hearing, I believe the date was stated in the notice, the chief requested the safety board to convene a hearing. Yeah, that request was made on November the 19th, 2024, so.
So it doesn't violate
No.
this policy.
It's my legal view that it does not.
You want to set a date for dismissal?
I would ask that you wait until after Christmas so that I at least, don't have to tell my family I'm unemployed over Christmas as an act of kindness.
I'm sympathetic to that.
I suggest that specific findings are necessary, that's a very good suggestion.
January 1.
That motion?
What's
the date?
January 1.
December 31st.
This is the last one.
So,
December 31st. Well, which is it?
Well,
December
the last
31st.
day in December.
Will be the last day.
last day of December, last day of the month.
Right.
That's a motion.
Second.
Second. All in favor? Aye.
So
One day.
further in reference to that, needs to be clarified, that are we requesting an equipment turn-in and maybe still perform his duties as a law enforcement officer from now till the 31st?
I think that's within the province of the chief. I mean, what's your suggestion?
Well, I feel if the order's been given for termination and it's been voted on by the board, that would stop his ability to proceed forward as a law enforcement officer
And
make him unable to enact arrests, to perform duties related to the town of Morristown in a law enforcement capacity.
But can I make this easy? Tomorrow is the only day left that, I have 2 days scheduled left till the end of this year with the holidays and all that. Tomorrow and then the Monday, the 23rd. I still have a personal day to use that I'd like to use on Monday, the 23rd, and then I'll just turn it in again tomorrow if that makes it.
I'm unavailable tomorrow. For that, this is my concern, is that are we opening the town up for liability by allowing equipment and the ability to act as a law enforcement officer after termination?
Well, okay, two things. Again, these statutes, in my view, are not perfect as they apply to towns. If this was,
Right.
Indianapolis, it's a different situation. The termination by motion is effective midnight of December 31st. You have stated you have vacation time, days off. The question then becomes Thursday, the 19th. Do you have any personal days, vacation days, or anything that you would not be engaged in any work activities on Thursday? I suggest that the board may grant him a paid day off in addition to whatever else he may have. Equipment must be turned in.
So finish paying him until December 31st. But
Right,
he's not due.
right.
Okay. I just didn't know what I had to
And
do.
on Friday, what's your availability to receive equipment?
I should be available Friday. Are you scheduled part-time at the school?
Tomorrow. Yeah, my only day out.
So that's my question, now, if we granted this.
Okay, and I don't understand the question simply because I don't understand.
To
the
work at
interplay
the school,
between
you have to have a police,
It has to be an active police officer, has to have this equipment.
to be in his firm.
I'll just call him tomorrow, it's not a.
Perfect.
Let's hear that. So,
So what are we exactly doing here?
he's turning his here on Thursday,
Friday,
Friday?
and we're
Sorry.
paying him until December 31st.
That's-
That's what I've gathered. Correct me if I'm wrong.
That's consistent with the motions made and approved this evening.
I got it all in there.
What's the motion? We voted on it,
Yes.
Before we vote, are we enacting a suspension of employment up
Yes.
to the day of termination?
Yeah,
Starts
absolutely.
immediately, or are we?
No, it's a suspension, based on the way these motions have been forwarded, the suspension is effective immediately
With pay.
with pay to the 31st. And the termination is effective on that date, which allows us time to develop the findings that are required by statute, circulate those for review and approval.
And we're under agreement that during that suspension, that just like before, there's
No law enforcement activities undertaken by Officer Wright.
So, we're good to go.
If you adjourn.
Make a motion to adjourn.
Did we make a final motion on,
I got December 31st last day, Ralph and Larry. This is paid until December 31st suspension with pay. And then at 4:01.
Made Larry,
Motion to adjourn.
seconded
Yeah.
Tammy, yeah.
Not what I never do. But